Good evening, attorney. Good evening, classmates. Under Article 136 of the Revised Penal Code, conspiracy and proposal to commit coup d'etat, rebellion, or insurrection. Under this article, the crimes punishable are conspiracy to commit coup d'etat, rebellion, or insurrection, and proposal to commit coup d'etat, rebellion, or insurrection. These crimes are breakdown into 4 punishable acts. First is the conspiracy to commit rebellion or insurrection, the elements of which are: first, the offender are 2 or more persons. They come to an agreement to rise publicly and take arms against the government, the purpose of which is to commit rebellion or insurrection, and they decided to commit it. The second punishable act is proposal to commit rebellion or insurrection. The elements are the following: the offender is a person or persons. He or they had decided to rise publicly and take arms against the government, the purpose of which is to commit rebellion or insurrection, and such person or persons proposes its execution to some other person or persons. Third is the conspiracy to commit coup d'etat. The elements are: the offender are 2 or more persons belonging to military or police or holding any public office or employment. They come to agreement to seize or diminish state power through a swift attack accompanied by violence, intimidation, threat, strategy, or stealth against duly constituted authorities of the Republic of the Philippines or any camp or installation, communication networks, public utilities, or facilities reached for the exercise and continued possession of power, and that they decided to commit it. And fourth, proposal to commit coup d'etat, the elements of which are the following: the offender is a person belonging to the military or police or holding any public office or employment. He or they decided to seize or diminish state power through a swift attack accompanied by violence, intimidation, threat, strategy, or stealth against any duly constituted authorities of the Republic of the Philippines or any military camp or installation, communication networks, public utilities, or other facilities needed for the exercise and continued possession of power, and such person or persons propose its execution to some other person or persons. Punishments of the following crime. Under Article 136 are the following: under conspiracy and proposal to commit rebellion or insurrection, it is prison correctional in its maximum period or fine not exceeding 1 million pesos, or prison correctional in its medium period or fine not exceeding 400,000 pesos. Under conspiracy and proposal to commit coup d'etat, the fine is prison mayor in its minimum period or fine not exceeding 1 million pesos. Under the case of the United States versus Simeon Figueras et al., GR number 1282, decided on September 10, 1903 by Justice Mapa, the issue is whether or not there is conspiracy between the respondents to commit rebellion or insurrection. The elements of conspiracy to commit a rebellion or insurrection are: the offender are 2 or more persons. They come to an agreement to rise publicly and take arms against the government, and the purpose of which is to commit rebellion or insurrection, and that they decided to commit it. The facts of the case are as follows. There are 3 witnesses presented on behalf of the prosecution, namely Paulino Legazpi, Laureano Martinez, and Petronilio Portugal. According to Paulino Legazpi, various persons, some 40, more or less in number, were conspiring to overthrow the constituted government, and stated that he knew the defendants were engaged in conspiracy because he heard them say so in their conversation the following: "What a life this is, so full of mystery, misery constantly increasing. When will our wretchedness end? When will authorities remedy it? What shall we do?" As to other matters, this witness this witness testify solely from hearsay and are doubtful. The issue again is whether or not there is conspiracy between the respondents to commit rebellion or insurrection, and the ruling of the court is no. The elements of conspiracy to commit rebellion or insurrection are the following: the offender are two or more persons, as alleged by the witness Paulino Legazpi. Some 40 or more are trying or are conspiring to commit rebellion. The second and the third element is they come to an agreement to rise publicly and take arms against the government, the purpose of which is to commit rebellion or insurrection. In this case, there was no proof that there was an agreement to commit rebellion or insurrection based on what Paulino Legazpi heard. And fourth, that they decided to commit it based on the stated facts. There was no decision to commit the alleged crime in this case. Hence, the court ruled in this case that the assertion of Paulino Legazpi appeared clearly to be the result of an arbitrary and gratuitous conclusion, because although these words reveal discontent on account of their evils, real or fictitious, to which they refer, they are not alone sufficient to prove the existence of a conspiracy to rebel, much less with the aid of force against constituted government. There was no agreement concerning the commission of rebellion, and there was no decision to commit it. Hence, the facts do not suffice to sustain a conviction of the crime of conspiracy to overthrow the government. Thank you.